the Institute for Justice. We are a public interest law firm, and we are funded by private donors, and we represent entrepreneurs, small business owners, individuals, property owners around the country defending their constitutional rights against unreasonable governmental interference. And we became interested in Chip's story and in craft beer generally when we heard what had happened to you guys at the legislature back in 2013. So I'm Chip's lawyer. We represented Chip for 2 years and two other breweries here in Texas, one called Petacolas up in Dallas and one called Revolver up in Fort Worth. All the way through the trial court. We won in the trial court. We had the judge declare that their constitutional rights had been violated and that the law we're going to tell you about had been struck down. And the state has now appealed that victory, and that appeal is ongoing. So we're talking about a live legal case today. But before we do that, I think we need to back way up and talk about alcohol and alcohol regulation. And in order to do that, I think we have to talk about prohibition. Right. So Chip, when you decided to open a brewery, was it your goal to become Al Capone? Was it your goal to become kind of this mobster and this like tough guy in the Austin area and kind of own the Austin area? Was it your goal to open a business?
A guy can dream, can't he? Yeah, it was even less than opening a business. Here we are at the business school. I have a degree in biochemistry, and I know when I got into the beer business, I knew very little about business. I just knew about beer. So, no, I wasn't trying to become Al Capone. And I really wasn't even trying to get into business. I was trying to make beer for a living. Turns out there's a lot of business involved.
Your mic is picking you up intermittently. I don't know if we need to move the mic up. Can you guys hear him okay? Okay.
I can speak up, too.
All right. But let's back up a little bit, because alcohol regulation in Texas and around the country is unique. All businesses are heavily regulated, and if you go into business, you'll find out just how heavily regulated they all are. But alcohol is regulated in ways that I think surprise people. If you were writing the laws from scratch, and you were going to try to protect consumers who are buying beer and consuming beer in this state, what kind of things might you be worried about? Q&A. Give me one thing you might care about if you were going to regulate beer. Selling to minors, fair enough. Go ahead. Okay. Maybe whether or not the product was adulterated, whether or not it harbored disease or harbored chemicals or things that shouldn't be in it. Maybe whether or not it was labeled properly. There's all kinds of things that government does when it regulates businesses that make sense to us, that make intuitive sense. That if we're going to protect someone and we're going to protect consumers, we care about whether or not there's metal fragments in beer or whether or not it has extra chemicals that got introduced. We care whether or not it's labeled properly so that consumers know what's in the product they're buying. We care, like you said in the back, whether or not beer is sold to minors. But beer regulation goes way beyond that. And it makes it much harder to run and operate, and I think much more expensive to operate a brewery than it needs to be in this state.
Before even Prohibition, there were admitted abuses by breweries upon the retailers who sold their beer, and it caused problems with intemperance, disrupting an orderly market, and the proper collection of tax revenue. And so what would happen is, say a brewery owned a lot of real estate, possible bar venues, and they would lease them to bar people that wanted to run a bar or a restaurant, and then they would require them to only sell their products. They would require them to buy a certain amount, and if they didn't, then since they were the landlord, or perhaps they had provided the bar owner with all of the tables and chairs, or perhaps the bar itself, they could put the screws to them and be very coercive. And it would cause these bar owners to give away beer for free just so that they could get some people in the door and go through enough beer. Anyway, it led to a lot of problems, and it's partly the brewers would have to get some of the responsibility for the reasons why prohibition happened. So upon repeal of prohibition, they wanted to avoid the same mistakes that had been made before, and they came up with what's known as the three-tiered system. And it was designed to create an orderly market, to encourage temperance, and to ensure proper tax revenue. Those were the three things that needed to be done.
And I can see people's eyes glazing over already.
Let's
let me
tell them what the three-tiered system is.
Well, I think that's right. But let's pause for a second. And you know, in any market, you have the same three tiers you do for beer. You have people who make a product, people who distribute that product, and then people who sell that product at retail. And those are natural functions of the market. But under the three-tier system, each of those tiers is required to be legally separate from the other. So Chip manufactures beer. He can't distribute it except under limited circumstances, and he can't retail it directly to consumers under limited circumstances. And that is dictated by the Texas legislature and by the legislatures of almost every state. And Chip, what is it like to operate under the three-tier system?
Well, we have some exceptions here in Texas, and if you're a small enough size brewery, you may self-distribute your products, but your products only. And to a limited extent, we may operate a tasting room and sell beer by the pint or whatever, as long as it is for consumption on the premises only. No off-premises sales. So as of 2013, we have a fairly good system to work within.
And the theory being that if you keep producers, distributors, and retailers separate from one another, you won't have the types of problems that Chip was talking about that existed before prohibition. But as with all regulations, that introduces the possibility of mischief. Because whenever you regulate an industry, you're using the power of the government to stop people from doing certain things. And that power is unique because it is the power of government. It is sovereign force that they use in order to enact these regulations. And so if someone can get a hold of the levers of government and get a hold of the levers of legislation, they can get laws written that benefit them at the expense of their competitors. And that is more true in heavily regulated markets than in less regulated markets. And it's certainly proven to be true for beer. Wouldn't you say, Chip?
Well, the most powerful lobby regarding the beer industry in Texas is the middle tier, the distributors. And so not only are our laws designed to ensure the existence of the middle tier, in fact, they require the existence of the middle tier. The middle tier has become very, very powerful, and they're able to manipulate lawmaking process, lobby, to make laws more favorable to the middle tier and less favorable, especially to the manufacturers.
In 2013, which is when the law we're discussing was written, craft brewers donated $17,000 to Texas legislators for their campaigns. Anybody want to hazard a guess how much money distributors contributed to Texas politicians? $17 million. So 1,000 to 1 in terms of the political donations. And you don't give somebody $17 million for nothing. You give them that amount of money because you're expecting to have their ear when you come to them with a law that you would like to be written. And that's kind of the secret of most regulation, whether or not you're talking about brewers, whether or not you're talking about African hair braiding, caskets, veterinarians, street vendors. These are all areas that my firm works in. In every case, the regulations weren't written because the legislature looked at something and said, oh, we have a problem here. Let's find the best way to regulate that and the best laws we can write to protect people. It always happens because somebody raises their hand and says, regulate me and stop this guy from doing something that competes with me. And so you had this 1,000 to 1 ratio in the legislature of these donations. And so these distributors wielded incredible power at the legislature. They still do. You guys have a craft beer guild that writes, pro-brewer legislation.
Yes.
But I would imagine you're still dwarfed by them even in 2017.
Oh, absolutely.
Yeah. I mean, how many brewers are members of your guild?
Right around 200 now.
Okay, wow, that's big. You guys have gotten big.
We've grown quite a bit.
And in my experience, looking at the types of laws that you guys tend to introduce versus the ones distributors tend to introduce, you're seeking to be more free. You're seeking to be able to do more things.
Absolutely.
They are typically seeking to make you or retailers less free and concentrate more power with the distributors.
That's right. And they don't pick on the retailers too much because that's their customers. But they do try and limit the power of suppliers. And what they will claim is that they're trying to limit the influence and the power of the large manufacturers like Anheuser-Busch and Miller Coors. And what they end up doing is, I hate to put it this way, but picking on the small guy because they can get away with it, and they make laws that are way further than they need to be, ostensibly to protect themselves from their large suppliers. It's an ironic situation that the beer distributors butt heads with their major supplier more than anybody else. And they're constantly at odds at the legislature. And they kind of use us to we're an easy target, and they use us to make laws that they think will protect them from the large suppliers.
So, Chip, why are distributors so powerful? Maybe we can talk a bit about distribution rights, which is the subject of this talk, and we'll talk a bit about the lawsuit. What is a distribution right, and why is it special in the beer context?
Well, at Live Oak Brewing Company, we've been in business for 20 years now. There is a special allowance for small brewers to self-distribute their products, but their products only. And we've taken advantage of that law for all the years that we've been in business, and we have grown quite a big business in beer distribution of Live Oak beer. So at Live Oak, although it's one company, we're essentially running two different businesses. One, we manufacture and package beer, and two, we distribute beer. So we do everything that the beer distributors do, just with a very limited array of products. So I've built up a distribution business. And we started our first week with 7 customers, and we finally had 20 after a few months, and we've grown it to be about 1,400 now. Well, there were a lot of lean years. There's a lot of work that goes into that. We do exactly what the beer distributors do, and basically it's supplying good service to our customers, the bar and restaurant owners. And so I've built up a big book of business, and if a beer distributor wanted to handle our products, I would be willing to sell them my business. My business with 1,400 customers is worth more than, say, a new brewery with 7 customers. The beer distributors had a law made that said, I may not sell them my distribution rights. I have to give it to them for free. Well, once they have been assigned the territorial right, pick some counties, and they are allowed to distribute my products in that county, and I've made that assignation, I may not get it back from them. And so it's perpetual. And it is exclusive. I may also not self-distribute in that territory anymore.
Or sell distribution rights to a second distributor. It's one distributor per territory.
That's right. So these distribution rights are worth quite a bit of money. If you look at the average beer distributor in any city, sure, they've got a lot of big trucks, they have some big real estate, a lot of equipment and cold rooms and computers. They're running a big business. But the value of their business is not so much in their trucks and real estate and their building. That's about 40% of the value of an average beer distributor. 60% of the value of a beer distributorship is in their intangible asset, the exclusive and perpetual right to distribute certain brands of beer in a given territory.
And that's a key concept. This distribution right within a territory is key to understanding this whole thing. So you currently self-distribute mostly in Austin and surrounding environments.
5% of our beer is in Austin.
Yeah.
Or around.
Yeah, and he can't, there are practical limitations with the law for him to distribute much past there because it has to come out of a warehouse that's in Austin.
That's correct.
So you couldn't put a warehouse in El Paso and distribute your beer out of El Paso.
That's correct.
If you wanted to go to El Paso, you'd have to find a distributor.
That's right.
And so if you were starting a brewery, and you would probably start local, you would grow just like Chip has locally because you can self-distribute. But the minute you want to go to Dallas, or you want to go to Houston, or you want to go out to El Paso, you have to find a distributor to distribute your beer.
Or you have to do, and I assume you're mostly business students, you have to do the very ridiculous job of loading up beer in the morning, driving all the way to Dallas in your truck, running around, dropping off a few kegs and cases of beer, and then driving back to Austin. A much more rational approach would be to rent a warehouse with some cold room space in Dallas, hire a guy who lives in Dallas, who can get up in the morning, go to the warehouse, and deliver around Dallas. But we're not allowed to do that. We're not allowed to have an out-of-county warehouse that holds it gets complicated, but our beer, our fermented malt beverage that is referred to in Texas as ale or malt liquor, that is, it has an alcohol concentration above 5%. 5% is the normal strength of beer. Our Hefeweizen, I don't know if anybody in here is over 21, but our Hefeweizen is our biggest seller, and it's about 5.1, 5.3%, because that's the proper amount of alcohol for a Hefeweizen. And so it is a ale or a malt liquor. And so our biggest seller, we couldn't warehouse out of our county. So it's a big problem.
Well, and these distribution rights per county or per city, you can divvy them up however you want to, have inherent value. The right to distribute Live Oak beer in Dallas or in El Paso is a very valuable thing because once you transfer it, like Chip said, to a distributor, it's gone for good. That distributor then has it and is allowed to resell it to a different distributor if they're adjusting their own portfolio. So we're talking millions of dollars here for any large territory. And if you have a successful brewery statewide, you can easily be getting into 7-8-figure numbers for the value of your distribution rights. And brewers would sell a territory and then take that money and reinvest it in their business. They would, sell, let's say, I'm just going to make up a number here, but let's say sell the distribution rights in Houston for $1 million. You then take that $1 million and grow your brewery so that you can supply beer to that new territory. And this is a successful business model for small brewers. What distributors realized was that there was rather than paying for these distribution rights on a brewer by brewer and territory by territory basis, they could run to the Texas legislature and get a law written that prohibited it. And that's exactly what they did in 2013. It's a one-sentence law. It says that you may not receive compensation in exchange for an agreement setting forth territorial distribution rights. And that was devastating to a number of small brewers. Ironically, or not ironically, but unfortunately, distributors are allowed to resell to another distributor for compensation. So if I am a distributor in Houston and Chip wants me to distribute his beer there, he would have to give me those rights for free. I could then distribute his beer as long as I wanted, and then when I was done or I wanted to adjust my portfolio, I could resell those rights to another Houston distributor for $1 million or $2 million and realize that value for myself, and Chip would get nothing for it. And that's often how laws get written. But the good news is that the government's ability to regulate is not unlimited. The government, generally under the Constitution, can regulate as long as it is actually protecting people and protecting the public health, safety, and welfare. I'm not going to get into all the laws and all the constitutional arguments for it, but that's the basic framework, is that you have the right to do business, to engage in enterprise, to have a job, to feed yourself and your family, and to grow a business. And you enjoy that right under both the federal and the Texas constitutions. The government can impinge on that right, but only so far as is necessary to protect the public health, safety, and welfare. And so the case that we brought against the state of Texas wasn't for money. We weren't seeking any damages. We were just seeking a declaration from the court that the law that the distributors passed in 2013 was unconstitutional and needed to be struck down. And last summer, that's exactly what the trial court did. They struck down the law, Judge Karen Crump in Travis County struck down the law and ruled that it was unconstitutional. Now, like I said, the state has appealed that, so we're up on appeal right now, and we'll see how that goes. But that was an extraordinary thing for a state judge or for any judge to strike down an alcohol regulation, because, and this goes back to the end of prohibition. The state enjoys tremendous power to regulate alcohol. It goes beyond the power that a government has to regulate Coca-Cola or to regulate iPods or iPads. It is a unique power because it's tied to the repeal of prohibition and to the three-tier systems that arose in its place.
But the three-tiered system is not what's legislated. It was not what was desired per se. It was temperance, orderly market.
That's right. That's why we have a three-tier system.
But the three-tiered system was a method that was supposed to produce that outcome.
And what we showed in court was that when you write a law that just benefits one party at the expense of another party, that doesn't protect the public from anything. All that does is protect beer distributors from having to pay craft brewers for their distribution rights. And a question you might have for yourself is, where were Anheuser-Busch? Where was Coors in all this? Well, they got rid of all their distribution rights a long time ago. Every non-dry county in Texas, somebody has the distribution rights for Dos Equis or for Budweiser or for Coors. It was craft brewers who were affected by this legislation.
But in spite of that, and to their credit, even though they didn't have a dog in the fight, they spoke out against
the big brewers.
The big brewers.
That's true.
They spoke out against these laws, as did the Texas Association of Manufacturers, the Texas Association of Business, the Texas Public Policy Foundation. There was nobody that spoke in favor of this law except for the trade association for about half of the beer sold in Texas, called the WBDT, or the Wholesale Beer Distributors of Texas.
But despite that, the law passed in 2013.
Yes. The chairman, perhaps I shouldn't say so much, but the chairman
We're among friends.
The chairman of the Business and Commerce Committee in the Senate was a very good friend of the WBDT, evidently, and without going into details, he pretty much rammed it down our throat, and he had us, and it was gonna pass, and it did.
So let's talk a little about what it's like to sue the agency that regulates your business.
It's a scary proposition.
Yeah, that is no small thing. And what did your friendly competitors think about you and Revolver and Peticolas when you decided to do this?
You guys take care of that.
We'll be right back here.
Yeah, we're right behind you.
And what happened when you won? Did that change the tune at all?
I think people are a lot more in favor of it. There are some people that it's been a little difficult, but they now think it might have been a good idea.
Mm-hmm.
Whereas before they were not necessarily thinking that it was a good idea.
Well, and part of the reason is because you have to sue the very agency you have to do business with every single day. I have my complaints, and one of them is that they continue on with these lawsuits that really only protect the middle tier, and I'm not sure what the state's interest is in that. On the other hand, I have a very good relationship with the departments and the individuals at the TABC.
I've known them for longer than 20 years. And so they're a very professional organization, and they treat us very professionally, and there's no retribution or anything like that. No. But I do think it's very unusual that they are working so hard to defend this law when it benefits not the state but the beer distributors of the state of Texas, where they have lost other laws. I'm thinking of Jester King, had a First Amendment suit that they won, that we could put, I mentioned beer versus malt liquor. We can now use the word ale on a fermented malt beverage that contains less than 5%. And we can call our fermented malt beverages below 5%, well, we can call them ale, and we can call the higher ones beer, because that's what they are. But they didn't try and appeal that, because that didn't harm the middle tier, as I see it. They lost that case, and then they just kept moving.
You guys are all B school students, or most of you are B school students. Is that fair to say? Chip, let's talk a little about litigation and kind of what it means to be in a lawsuit. Because one piece of advice I always give people is, if you can avoid going to court your entire life, do it. Because suing people, and certainly being sued, sucks. You expose yourself to discovery, where they can go after your financial information. You expose yourself to depositions, where they can sit there and ask you questions for 7 hours. It's always expensive to sue somebody unless you have a law firm that'll do it for free. What was the litigation process like? I mean, what would you tell somebody who's thinking about being a business owner or being in business about litigation?
The same thing. You don't want to sue people. It's a big pain. And we would have never been able to do this had it not been for the Institute for Justice, who's working pro bono on this. This is the kind of lawsuit that they do. They're interested in economic liberty issues and property rights issues, and this could never have been done. And I think if I want to think cynically, that's probably one of the reasons that the WBDT pushed this legislation, is because they knew that we wouldn't be able to fight it. I could not have done this if it had not been for the Institute for Justice.
Excellent answer.
Yeah,
exactly where I was hoping you were going to go with that.
Yeah.
No, but again, I'm thinking if I'm sitting in the audience and I'm you guys, what do I care about? And you will have to deal with lawyers in business. You'll have to have lawyers. But anytime you kind of feel that impulse to sue somebody or to lawyer up, or your hackles get raised, I encourage you to resist it. Because being in court is not fun, and suing people is not fun. Have you been involved, Chip, in any case besides this one? I mean, anything of any magnitude besides this one?
No, this is the first time.
Yeah. And this will hopefully be the last time?
I'm hoping, but I am pretty active with the State Guild, and even before that, individually, I was active down at the legislature. And I enjoy that to a certain extent. I mean, a lot of people think that's not fun, but it's really, really interesting. So, you might want to get into a business yourself, and you really enjoy whatever, basket weaving. But I guarantee you, there's going to come a day when somebody's going to make a law that says you can't use that kind of material, you got to use this kind of material, and it's going to impinge upon your business, and you're going to be very interested in the legislative process.
Well, yeah, what do they say about, you may not be interested in the legislature, but the legislature is interested in you.
Yes.
And it's kind of a constant battle.
Yeah, and we get very nervous, every 2 years for about 140 days. What's going to happen? You want to talk a little bit about this year's legislation and kind of what you guys are working on for craft breweries? There are two pieces of legislation that we're very much against, and there's one that we're very much in favor of. The one that we're in favor of is fairly easy. It's not going to be easy to pass and may not. But it's easy to wrap your head around. People come to our brewery. We're on 22 acres of beautiful Texas land right on the Colorado River. People come to our place to go to our tasting room and hang out in the beer garden and play disc golf. We would love to be able to sell people. We're across the highway from the airport. We're about 7 minutes away from the airport front door to ours. So we'd like to be able to sell people a six-pack to take with them. Or perhaps a couple of guys want to get a six-pack and go play a round of disc golf on our property.
Sounds dangerous.
And we'd like to be able to sell them some beer for consumption off premises, as it's referred to. And we got the right in 2013 to sell beer by the pint or by the glass at the brewery, but we'd like also to be able to sell off premises. The only people that are against it are the beer distributors. I'm not sure really why they're against it, but the reason that they always give is that their retail partners are going to be against this because we could be selling beer retail that their retail partners would otherwise be selling. But we get in contact with them, we sell to them, we know them, and we ask them about it, and this doesn't give them heartburn at all. In fact, they see our ability to sell a small amount of beer to take with you as a way of marketing. Nobody's going to say, oh, well, I'd like a case of Live Oak for the weekend, having some guys over. I'm going to pass by 3 HEBs and drive all the way to Live Oak Brewing Company when I could just get it at HEB. They know that's not going to happen. And so these are opportunity sales, and it's not going to be the way the guy gets his beer every week. So anyway, we're not sure what the real reason that the beer distributors don't want us to do this. But one could be cynical and just think, well, any beer that doesn't pass through their hands it's not a sale for them. Doesn't give them any money.
But doesn't that get old? I mean, this constant push-pull in the legislature where rather than crafting legislation that is good for the state, that is a reasonable and rational way to regulate an industry, every 2 years you guys have to march down to the Capitol and defend yourself from the distributors and try to claw back just a little bit of territory for yourselves. I mean that is no way to govern.
That's right.
But that's what we have. And the reason is that the government enjoys extraordinary power to regulate. And so people try to find ways to use that power to benefit themselves.
There's these laws that allow us to retail, and this is going to be the first the first bill that we're trying to defeat. So there are big limitations on us because we are a manufacturer. They want to keep separation between the 3 tiers. And so they allow us to retail a limited amount of beer and only the beer that we produce in our brewery. That's what's been passed. So I can't sell Anheuser-Busch, I can't sell liquor, I can't sell wine. I can only sell Live Oak beer. And I can only sell a certain amount. So they're trying to pass a law now. Well, here's another thing that's happened in the business. There are bigger players that are getting very interested in the small breweries, and they're wanting to buy them. Karbach in Houston was bought by Anheuser-Busch. Revolver, one of our co-plaintiffs, was bought by Miller Coors. Independence Brewing in Austin was bought by a larger small brewery, Lagunitas.
Ironically, since it's called Independence.
Yeah. And so they're trying to pass a law now it's sort of this. They're trying to pass a law that says if you are owned by a larger brewery and somewhere at another brewery they happen to make a lot of beer, you may not sell beer in your tap room anymore. Well, what's the state's interest in that? The law is already written. The beer distributors will tell you it's because we don't want, say, Anheuser-Busch to be able to sell their beer in your tap room. Well, the law already says they can't. We don't want Anheuser-Busch to be able to sell your beer in their tap room or their beer in their tap room. Well, the law already says it can't. So it's worse than belts and suspenders. It's making a new law that takes away an asset from me. So what if I want to sell Live Oak to Anheuser-Busch? Well, I've got this beautiful brewery, got this beautiful beer garden and tasting room, got disc golf. It's worth a lot of money. Oh, and we also make some beer, and that's worth some money, and we sell it. Well, now the beer distributors want to pass a law that takes away this very valuable portion of my business. And I got nothing to, I have less to sell. So that's a law that we're trying to kill, or a bill that we're trying to kill, where they take away a portion of our business.
Chip, what portion of your time is spent dealing with the law and legal compliance and TABC and all this regulatory framework that governs craft beer?
That's most of what I do now. I got into this because I was into biochemistry and
he has a PhD in biochemistry. It's Dr. McElroy, by the way.
And I like making beer, and I liked the science of making beer. And in another talk, I can bore you to death with details about beer and enzymology and fermentation and yeast. That's why I got into this. Somebody's already nodded off or walked out. Well, that's why I got into this. And now I'm having to spend all my time not working on beer recipes, not hanging out with the brewers, brewing some beer. I'm worried about legislation and keeping my business alive, not because we don't sell anything, but because there are other people that are working against us at the legislature.
Well, and I think that's one of the key points about your case was A, it struck down a bad law and a law that never should have been passed. But B, it established that you can strike down these laws. It established that there is some outer boundary on the legislature's ability to regulate brewers, and that they can't go beyond that outer boundary. And that is a rare thing in courts. And distributors, certainly when they're running around the legislature, act like there are no boundaries. That any law you can get written and passed is fair game.
Well, and they also think that the 21st Amendment, which was the amendment to the U.S. Constitution for repeal of prohibition was the 18th. They believe, because it does give the regulation of alcohol in a state to the state authorities. But there was another court case, went all the way to the Supreme Court, and I believe you all did it.
We did.
It was the Granholm decision, and it said that, sure, the 21st Amendment allows states to regulate alcohol, but they can't make unconstitutional laws that trample on some other portion of the Constitution. And so the 21st Amendment does not trump every other bit of the Constitution. Mm-hmm. Now, this was a problem for the beer distributors, and it really caused them to start quaking in their boots because they run the state legislatures. In all 50 states, it's the beer distributors who are making beer law, and they wanted to have their way, and they wanted a Supreme Court decision that said the 21st Amendment trumps all, but it doesn't.